rate. I apologize to you, Ms. McGann, because I know this estate has been a nightmare. But
I understand, Judge, but I would like to say in Rutland it is $350. In Burlington it is $450. I don't know why Addison is at $250. I have no idea.
But and I've seen fees from different places. I've also disapproved. I've seen a bill from Chittenden County case at $450, and I disapproved it. And the attorney agreed to reduce the hourly rate because, I know attorneys in Chittenden County charge a great deal more than maybe they do in Rutland County. I'm going to reduce your rate to $275. And as I say, I apologize. But I find your time is reasonable given the complications of the estate. Ms. Durkee.
We could not find an advocate who was willing to take it on, and that's why we had to go out of the county.
Yep, and I understand that, and I'm not blaming you in any way, and I thank Ms. McCann for taking on this miserable estate. This has not been difficult, and it probably this has been difficult. It has not been easy, and I believed in another case. I did approve your rate at $350,
Yes.
but that was an estate that had assets.
Right.
So, to me, it depends on if there's assets. I have seen some bills at $350. As I said, I disapproved $450. I simply think that's ridiculous for the administration of an estate. So I'm going to reduce your fee to $275. Now we'll move on to Roy's VA benefits. I would assume that his VA benefits stopped at the time that he died. Is that true, Ms. Durkee?
The bank statements that Ms. Packard so meticulously went through clearly show a withdrawal of the VA benefits in January along with the Social Security, and that no further benefits were deposited to that account. So I don't understand why she can figure out all these other fees in it but not see that nothing has been deposited, and in fact the VA benefits were withdrawn.
Okay. And the VA benefits were not paid after the opening of the estate, so the court finds that to be irrelevant. With respect to trash removal, I will ask Ms. Durkee what required 7.25 hours to remove. Having seen the pictures, I can only imagine, but go ahead, Ms. Durkee.
My dad had dementia, and as part of keeping him in his own home where he's happiest, I had to go over and medicate him twice a day, and then the shopping and laundry and medical appointments and all that. He let the trash pile up in the kitchen rather. And with my dad, you had to pick your battles. So taking care of his medication, taking him to medical appointments, getting him out of the clothes he had worn for 3 days so I could wash them, making sure he had eaten properly, were the battles that I did fight. The copious amount of trash I didn't, because he rinsed everything out so it didn't attract rats. And there was a lot of it. That's why we had to rent the pickup truck.
Okay, and then you had to take that to the transfer station and dispose of it?
And they let us do it as a clean out. It would have been a higher fee if it had been residential trash. So I was grateful for that.
All right. Searching for the original will.
Your Honor, if I may, and just so you know, because you can't see me raise my hand, I am putting in chat when I'm raising my hand.
Oh, okay. Can you monitor that?
Yeah, it doesn't always show up, but yeah.
Okay.
Okay, I have
I don't
seen,
see the check because I'm not on WebEx, but I've just asked the register to monitor that. So the
okay, so
will,
I'm sorry, I had one quick question, which is why I raised my hand. I've seen
Okay,
the
go
size
ahead.
of that kitchen. I've actually been in the trailer. There is, I don't care how much trash he had in there if he had it packed into the ceiling. That would take an hour to clean out. There is no
Okay, it might
possible
take
way. There
you an
was
hour
enough
to clean out,
garbage.
but that's cleaning it out, packing it into the truck, transporting it to the transfer station, unloading it, and maybe more than one trip.
Plus, we had to go in and pick up the rental truck first.
Okay,
had
so
to
she's
drive to
talking
thank
mileage and everything.
goodness there was an enterprise rental still there. So we had to drive in, pick up the rental, leave our vehicle, go back to Shoreham, get the trash loaded, go to the transfer station, unload the trash, and then go back to Enterprise and give them their vehicle back.
Okay. So there's a will dated April 28th, 1995, which was not allowed by the court because it had only one witness, that being Kathy Telgen,
Belgian.
assistant clerk. And you had to have, at that time, you had to have 3 witnesses to a will, not just one. Today it's 2. So it wasn't valid. But wills are not necessarily given. In fact, I've written a will. My son, who's the executor, he does not have a copy of it. It's filed here with the Addison Probate Court, but it's not normal. Sometimes people choose to give it to their executor, but other times it's not. So, given the state of Mr. Durkee's home, the court would not find it unreasonable that it would take time to locate it.
My dad had a unique filing system, Your Honor. The cardboard box. And when that one got full, he took another empty one and put it on top and then filled that. And they were 3 high and 2 deep and 2 wide.
And to what? I think that unique is a good word for it. So let's see, retrieving ashes. Okay, we've already discussed the military funeral and things like that. The Durkee, I would like to discuss the Durkee, Roy Durkee's business. Okay. Ms. Packard, how did you come up with an amount that has never been even discussed previously in this case of $529 some thousand being unaccounted for the dissolution of Durkee Lumber Company?
I've actually mentioned it a couple times, Your Honor. The $400,000 is what he got from Chittenden Bank, what he and Wendy got from Chittenden Bank. And there was a $129,000 settlement with the Commonwealth of Pennsylvania as well. And none of the money went to pay any of the bills, obviously, and remains unaccounted for.
Okay, please tell me more about the Chittenden Bank. I know that there was a loan from the Chittenden Bank that was memorialized in the, I'll have to look at it again, but in the, I think Chittenden Bank had a judgment against Mr. Durkee, if I recall.
Correct.
So please tell me what else.
There were actually 2 different loans that they were given, and those amounted to the $400,000. And it was shortly before Durkee Lumber Company dissolved. And then there was also the award from the Commonwealth of Pennsylvania for the $129,000. That was shortly before Durkee Lumber dissolved as well.
Do you have any evidence, Ms. Durkee, that those funds were, not used to pay the bills that Durkee Lumber had or your father had for the mortgages and other things that he had with his business?
He didn't have a mortgage, Your Honor, number one. And number two, all of the creditors showed that they were not paid. Where'd the money go?
Okay, so you're talking about money that went somewhere before the estate was opened. Did it go somewhere before your father died?
That's what I'm wondering, Your Honor. Where did it go? They got $529,000. Durkee Lumber Company was dissolved. All of the creditors stated they were never paid back. Chittenden Bank was never paid back. Nobody was paid back. It certainly didn't go to pay any of the property taxes or anything. According to Wendy, she paid them all. Where'd the money go? He owned all of the equipment. He owned the property. He had no mortgage. He certainly didn't go on trips, and he lived in a dumpy old trailer. Where'd the money go?
Let me ask Ms. Durkee, although I think we're talking about a period well before his death and certainly well before the opening of the estate. Let me see what Ms. Durkee can tell me. What can you tell me about this?
So, number one, it occurred even before the guardianship.
Okay,
I don't understand why we're wasting the court's valuable time on this.
I'm just trying to understand
The
it.
last loan I co-signed, was about 100, maybe 30, maybe 50. And then, when my father was not able to get the sawmill up and running, the Chittenden Bank started charging late fees and this fee and that fee and finding Jimmy Hoffa fee, and it ended up being a $400,000 claim that they put against my dad, which is the reason I never closed the guardianship, because I knew that claim far exceeded the value of the property.
Okay, apparently it's now been discharged or something. It doesn't exist anymore, but
You said it was not perfected in a previous hearing? And it is
Right.
no longer at the town clerk's office?
that's what the title search brief and memorandum indicated. I am wondering though, Ms. Packard is saying you received this money, you and your father received this money as
130.
part of Durkee Lumber. When was that?
Before 2016. I don't know, it's ancient history.
Your Honor?
Yes, was that Ms. McGann?
Yes. I believe the title search actually gives you the dates, and Durkee Lumber went out of business in 2007. You might recall when we started this, we explained the original principal borrowed was like 130 to 150. Mr. Durkee then participated. He did have a lien against him, a judgment against him with excessive fees up to $400,000. He participated in some type of civil matter down in Pennsylvania, and the restitution paid to him was $129. And Wendy, you told me that he paid Chittenden the $129. No?
The lawyer in Pennsylvania stole it. My dad had not signed a percentage agreement, and he billed more hours than what the settlement was. He lost his partnership over it. They stripped him of his partnership because of it.
I mean, the lawyer got into ethical trouble over it, and
He
he lost.
lost his partnership down in Philadelphia because of what he did to my dad.
What was the lawyer's
Talk about
name?
penny wise and pound foolish.
But so I just want to be clear. We're talking about things that happened 20 years ago, or, not necessarily exactly, well before this estate, well before even the guardianship. The court rules that those are irrelevant.
Thank you, Your Honor.
How is that
We
irrelevant, Your Honor? Just out of curiosity, because obviously the money's somewhere and they kept it. So why is it not relevant where the money went? If he had that much money, or even half of it, then it would.
Well,
Then just
even if you assumed that he actually received the money and kept it, we're talking about so long ago that it could have been spent. Now, granted, looking at the pictures I've seen in this case, I would find it very difficult to believe that he had $400,000 in cash, because he probably would have upgraded his living situation and gotten rid of some of the trash had he had that. I suspect that they went to pay other things.
they didn't, Your Honor, and he was a hoarder, so no, he wouldn't have gotten the stuff.
He borrowed money, $130,000 to $150,000 initially. It sounds like, from what Ms. Durkee said, to get a sawmill up and running. And Chittenden Bank, with various fees because he didn't pay it, claimed that he owed $400,000. So let's say he got a settlement for $400,000 somehow. I don't even know how he would have. It is not the responsibility of the estate to deal with that.
If he had that money before he died, though, why is it not part of the estate, just like the scrap metal is?
Because it didn't exist by the time the estate was opened, or even by the time of his death. I will check the guardianship file, but I will expect that the guardianship file does not show any assets in the area of $400,000 in the file. I will check that, though, before I issue a final order in this case, to make sure that that is the case. Now, we're going to take a brief recess now, because we've been going for almost an hour and a half. I certainly need to go use the restroom, and we'll take up what's left, but I don't think there's much left that we need to take up. I think we've addressed most of your issues, but we will take a brief recess and come back, say, in 10 minutes. Sure, take a recess.
Yeah, I'm actually leaving. I'm going to have somebody else because, oops.
Not right now. Not right now. Not. Thank you.
Ms. McCann is back. Ms. Packard, are you back? Oh, unmute her, please.
Yes, I am.
Okay, and we're going to resume. I have asked that the guardianship file be located, and I will, my goal is to get an order out tomorrow, before 1 o'clock tomorrow on this case. So, Ms. Packard, I want to give you the opportunity to point out anything new that we haven't discussed that relates to the estate being opened in 2021. We had an inventory that did not show any money, or very little in terms of cash, certainly not 400,000, and any 400,000 or 129,000 that may have been received by your father in the early 2000s or late 1990s are not before the court. So is there anything else that we haven't addressed relating to the estate that you want to raise?
Well, you have everything, as far as I know at the moment, Your Honor, that I had issues with. Unfortunately, and I am just going to say that, for the record, that Wendy lied, because on July 28, 2005, they increased the loan to $406,000. And she signed on it, so she should be aware of that.
You're saying in 2025 the loan was increased?
No, Your Honor, 2005. For the
2005.
that is what
But
she signed on.
Loan proceeds of a loan are usually used for whatever purpose the loan was taken out for. In any event, it's irrelevant because it's well before either the guardianship or the estate.
Your Honor,
If there was an outstanding debt at this point of $400 and whatever thousand to the Chittenden Bank that was secured by the loan,